May I mention, Millard, item number 63 today. So I have already served the notice to the government pleaders, Millard. My matter pertains to the violation of human rights, not only in Bangladesh, but also in this part of our country, where people are being sent back, knowing full well that they will be murdered, killed, and their family will be raped. It is under Universal Declaration of Human Rights, Millard. India government is bound to give shelter to the distressed people who are under threat of murder.
If it doesn't reach today, we will upgrade the matter next week.
Next, Millard.
If it doesn't reach today, we will upgrade the matter next week.
Millard.
You please
Millard.
give the number. Item 63, Amnesty India.
Yeah, Millard. Millard, a date be fixed next week.
Let us see how we progress today.
Yes, Millard. 63 would not be coming today.
Let us see.
Millard.
That contaminated will also sitting with the Justice Fortuna. That is the NVSTC. Till now, they have not given the appointment.
So yesterday we sat that division bench. We didn't know.
It's a matter we heard.
All right, we'll constitute one.
Medical and police verification are all completed, but till now the appointment.
Yes, madam.
Well, may be permitted to mention a matter pertaining to the original site, Lordship. The matter was made returnable on 4th of December. I am the respondent in the matter. Because of the pendency of this particular appeal, my pensionary benefits are not being disbursed to me. There is no order of stay, Lordship, as such.
Pensionary
Benefits, Lordship, because there was a proceeding under the PMLA, and in connection with that, there was a disciplinary proceeding.
That is, they recommended that CBI.
Yes, Lordship. Yes, Lordship.
And you succeeded before the Central Administrative
Yes,
Tribunal.
Lordship. And the learned, the Honorable Single Judge has been pleased to allow my writ petition. They have filed an appeal against it. It is pending, Lordship. If it's taken up
Let us see
tomorrow,
what
Lordship,
can be done
because,
next week.
Because I have suffered 2 cerebral strokes. My client has suffered 2 cerebral strokes, my lord. I have annexed all documents, Lordship. Any day, any time tomorrow, my lord.
You give it to Anjan.
Tomorrow.
I have, my lord.
Yes, please.
Well, I pray this matter may be come as to be mentioned, my lord. My lord, I pray. Because it is very urgent matter. The unauthorized construction is going on. Yes.
Both the state unauthorized constructions going. Every matter is urgent matter.
No, my lord.
You give, let us see what can be done.
Get
Yes.
to the
Lord.
My lord, this matter regarding the inclusion in the list.
Lordship, a program is going on 7 February to 10 February. The program is big firecrackers illegal private respondent.
It is listed today.
60. Before 2 days, I mentioned that matter, but all cases urgent.
Let us see today, because some matters are to be mentioned. It may go off.
Lordship,
please wait. If it is not there, we will upgrade.
Oh, please.
Yes.
May I have my lord's kind leave to file one urgent application, my lord. This is in connection with a public interest litigation. My lord may recall the matter is this dismantling of hoarding in Bidhannagar.
Yes, yes.
My lord, on the last occasion, my lord granted us liberty to give a representation in detailed form.
And when is it returnable? We have given a date.
Yeah, my lord has given. Now we have filed that representation before the corporation and asked them to conduct a hearing process. But they are going on dismantling, my lord. If my representation.
No, it will come on the set day. We can't advance the matter.
Lordship,
You
my
please give the,
I have given
you file the application, give the application number, it will be listed.
It will kindly takes up today at any time, my lord, because
Not today, not.
because my infractions, my lord. I mean, I have given.
We can always put back. You can we can direct, if it is found to be illegally removed, we can always issue direction for restoring it to the original.
At least
Yes.
For inclusion,
please give the number and the application.
Yes. For inclusion in the list one.
The Lordship, if to mention a matter, Lordship, the item is listed as item number 197 of today's list. The matter pertains to the ex-commissioner of police, that RG Kaur matter, Lordship. Your Lordship, we have to place the Supreme Court's order, Your Lordship, if the matter could be upgraded any time.
197.
Yes, Lordship.
All right, we will make a note of it. Let us see.
Lordship, may be permitted to mention for a correction, Lordship. The senior counsel, Mr. Bhattacharya, was there, but his
name has to be included.
Yes.
This is appellate side matter or
appellate side matter, madam.
Can we show it in today's list? Day's list and include just senior advocate's name.
This is item 195 of today's list.
ground of urgency is that illegal construction is going on, that is all right, man.
Hmm.
Madam, it is being, the illegal construction is being constructed by filling of the pond, my lord. The building can collapse.
All right, you give, we'll see whether we can upgrade it. No? Yes, please call the list.
Appellate side daily list, item number 1.
Well, this is my application. I am for the petition.
I am appealing on behalf of the CAN 4.
Now, my lord,
The order was
before your lordship opened it, your lordship kindly come to your lordship's order dated. Yes, yes. They have, as per your lordship's order dated 18/4/2024.
Hmm.
Initial order is 18/4. Paragraph 8, your lordship kindly see. This is the specific allegation regarding illegal plying of the vehicle.
Paragraph 4,
Paragraph 8.
paragraph 8.
Yes.
Yes.
Now, my lord, this order was extended on 19/9/2024.
They were required to file a report.
They have forgot to. Now, my lord, your lordship kindly see the report. Next, I shall make the submission. First of all, they are to, in the report, they are to indicate CAN 4. The illegality is indicated in CAN 4. My lord, in my humble submission, not a single illegality has been indicated in CAN 4. What they have indicated, I want to place before your lordship. Your lordship kindly see. Report to them. Not a single sentence has been written on CAN 4.
Where is the report?
third.
Who appears for the state?
Mr. Sen.
Mr. Sens Junior is here. This is report dated, affirmed on 8th January. 8th January. New report to be filed.
Third report. This is a revised report. Revised report affirmed by the Secretary of State Transport Authority. Third report.
Third report.
Third revised report.
But where is Mr. Yes, he is coming.
This is the report.
Third revised report.
Because my lord was not satisfied with the third report.
Huh.
Though my lord, I was my lord directly withdraw, but a copy was my lord.
Now, what has happened?
My lord, may I tell one? My lord, the time to time, the report filed. Up to third report, my lord, it appears that my lord, steps were taken by the motor vehicle inspector along with the police personnel. My lord, they time to time, my lord, they intercepted the vehicle. Now, my lord, so many persons, my lord, they have been, my lord, issued the so-called notices. Some of them replied to the so-called notices. Now, my lord, we, my lord, slapped upon them fine. And, my lord, who for the consecutive second time, it appears that they flouted the norms in their cases, my lord, in terms of section 86. Another so-called notice for, my lord, suspension or cancellation of the permit was issued. Now, some of them, my lord, replied. Now, my lord, it appears that, my lord, so far that reply is concerning case of some of them, my lord, we considered and we again, my lord, warned them. But some not even replied to that so-called notice for suspension and or for cancellation. Against them, my lord, the cancellation procedure was, my lord, about to be issued or steps to be taken. But in the meantime, my lord, some filed, my lord, one after another CAN application. So we stayed our hands. So far, those matters, my lord, those remain.
No. Which
Now,
are
your lordship kindly
My
see.
lord, the entire details are, my lord, being reflected in this, my lord, the report. So far. Because me, I tell, my lord, the third report, my lord was kind enough to dissatisfy
Can put
the
the
parties because of the fact there is a one CAN application, CAN number 4, which is in support of the writ petitioner.
yes.
In CAN number 4, my lord, some details are there that who are regularly flighting this. Their bus numbers, vehicle numbers are there. My lord, we missed that CAN number. That was misplaced. Then, my lord, after that, my lord, having been served again, my lord, we took steps. Now, my lord, that has also been, it appears, that case of most of them, what was reflected in that CAN number 4, most of them are, my lord, already they had been issued the support notices and steps taken. Now, my lord, this is, my lord, the report, my lord, I have circulated as far as possible to the, my lord, the parties who, my lord,
Now,
wanted to participate.
today's in the today's list, There are 1, 2, 3, 4, 5, 6, 7, 8, 9 can applications.
Nice.
We will come one by one. What is can 6 of 2024? What is the prayer in can 6?
We can to action of
Madam, may I tell one thing? May I suggest one thing today? If your Lordship, my Lord, take it. Madam, may I tell one thing? May either of us or me, Madam, come back on the next, any earliest day. My Lord, there should be a synopsis with regard to the can, that this is the can number 1, and the petitioner in can number 1, his grievance is this in one column and he wants this relief. Now, Madam, may I come back with this synopsis? Then it would be helpful to all of us, my Lord. I think because, my Lord, there are in a scattered way, my Lord,
But I will suggest, my lord, that in the meantime, we can take exception to the report. Perhaps it will be easier for your lordship to understand, my lord, appreciate our respective
Because
points.
today all these applications are being filed by the existing operators.
Yes,
Some of them saying that they are being harassed
right.
because of this direction. There could be cases where repeated offenders are there. So, pendency of the can applications will not be a bar for the RTA or STA to take the matters to the logical end.
Very well.
If he doesn't respond to the show cause, you either suspend or you issue a fine, enforce a fine, or you issue a warning, whatever it. We have not granted any stay of any proceeding. The only endeavor of the petitioner and the applicant in Can 4 is that these violators have to be brought to books, so that the existing operators, they continue to ply their vehicle. Interstate operators where permits have been countersigned, they should not be harassed.
Well, only thing, my lord, some of the existing operators, their common grievance is this. What it appears from the, my lord, subsequent cans which have been filed before your lordship, they are, my lord, the stage carriage operators of having interstate permit.
Correct.
Suppose permit issued by other state. Now we are the reciprocating state. Suppose either we have issued permit or we countersign the permit by the STA. Now their contention is that in their permit, that the, my lord, the routes are mentioned. Suppose instead of a specific area of Calcutta, the only Calcutta or Kolkata. This is that this bar imposed by way of the judgment of this Honorable Court culminated into this notification issued in 2004. They said that this bar is not affected so far we are concerned.
That is our case.
But my humble submission is this, my lord. I would make my submission on that point is that a judgment delivered by this Honorable Court, when restraining that nobody shall enter or ply their vehicle or no access to that particular area, bearing a few mentioned therein, then that is, my lord, applicable to all, irrespective of the fact that the permits have been issued in Calcutta instead of mentioning therein. Even if there is a, my lord, the mention in Calcutta, but my humble submission would be on the next day, my lord, that the permit is nothing but a contract. A contract. I applied for a permit. Then, my lord, the permit issued on the basis of the terms and conditions. If it appears under section 56 of the Contract Act that subsequent to the terms of the contract, if a law comes and the law says that these terms is illegal, then that terms would go. That contract would go. The law will prevail. And that is the section 56 of the Contract
But
Act.
the question is,
So, my lord,
did the law say so?
The law
short
is
question is,
and the motor
did
vehicle
the
act
notification
says
say
that
so?
In the permit, interstate permit, it has been mentioned as Kolkata.
Kolkata.
In the notification, you have restricted the area,
Restricted area.
saying that
Banning this.
Huh?
Banning this.
banning this area. So it
You can apply
Suppose-
banning that area.
Another aspect of
My
the matter
contention
is
It should be subject to this condition.
My
And that
contention,
is the
sorry.
exact section 56 of the Contract Act.
My contention is this, that it is not within that area that I am operating. That will be my submission before your lordship, and your lordship will
and,
discuss.
which is your can applications.
Well, can two.
can do.
can two bar karo to? What are can 6?
or addition and or correction and or amendment of route Baripada to Kolkata via Lakshmana and back by Baripada to Central Bus Stand at CBTS Drive via Lakshmana on
That will amount to the minor the
Variation.
scope, extension of scope of the writ petition. Writ petition is a public interest litigation.
বলতে দাও ওকে
Our prayer for amendment, correction of the constant.
Not yet it has been done.
That they will do.
That has not yet been
No,
considered.
that is beyond the scope of
That is
this
the
writ petition.
writ petition.
They are being harassed.
No,
They will
we have
be
made it
harassed.
clear in our earlier order, under the guise of implementation of this direction, there should not be any harassment. Let us assume, like where
It must
senior
be done,
counsel is appearing. According to them, this notification will not tantamount to varying
yes
the
absolutely
permit.
yes
It's a separate cause of action. But suppose, according to you, you want to implement the notification in supersession of the condition in the permit, you will have to put them on notice. And if they are aggrieved, they will, you accept their plea, well and good. Otherwise, they have got other remedies to do. We are not here to, what is it, regulate the entire operation, bus operations here. No. The public interest writ petition got highlighted only in respect of certain violations committed by certain
Who are in respect of a certain particular area.
And how
The
the
issue-
harass kindly come to can 16 of it.
No, you are sir. All these
If
applications.
everybody would come and say that it is nothing but harassment.
তোমাদের বলছি
No, all these can applications we cannot consider because it will go beyond the frame.
বলবেই মক্কেল বলেছে বলতে
Not required. That's a separate cause of action.
My lord, I filed one writ petition before the Honorable Justice Raichottopadhyay, my lord. My lord, he refused to grant any.
We will clarify it today.
And granted.
Sir, so far as they are concerned, yes, they are concerned, their permit as on date has not been altered. It says Kolkata.
Yes.
According to them, they can come here, come there, everywhere in the Kolkata, the buses can fly. You say no, because of the notification, the buses have to terminate at this point
Right,
A.
right.
You issue them a notice, they will reply. And in this PIL, we can't be doing it.
No, my lord, one thing I shall indicate to reply to Mr. Mitro.
No, you're expanding the scope of your.
No, I'm not expanding. I am only concerned about your lordship's order.
No.
I
Today we dispose of all can applications, saying that under the guise of implementation of the directions issued here, the existing permit holders should not be harassed. However, if the authority is of the view that there is violation of permit condition, it will be open to the authority to issue notice to the individual permit holders.
Right.
And after following the procedure under the Motor Vehicles Act and the rules, they will proceed in accordance
I
with
think
them.
that's the best.
very well. One minute, except can 4, because
Can 4 we will not dispose of. All other cans will be disposed of today.
very well. I am only
You file.
in my writ petition. I am only asking for that prayer only.
Please, sir, all these applications have been filed by the existing stage garage operators, some of whom are interstate permit holders. Others have been issued permits to operate within the state. All of the applicants seek for impleading themselves in the writ petition on the ground that under the guise of implementation of the various the directions issued by this court, more particularly in the order dated 18/4/2024, the existing operators are being harassed. In fact, we had made it clear on the earlier occasion that under the guise of implementation of the directions issued by this court in its order dated 18/4/2024, there should not be any harassment of the existing operators. According to the state, though in the interstate permits or other permits, the terminal point is mentioned as Kolkata, there is a subsequent notification which restricts the entry of such vehicles within certain limits/area. And according to the state, this notification is in effect a law which would supersede the condition in the permit, namely with regard to the point of the terminal point for the vehicle. In our view, all these are all individual cases, and if the authority is of the view that any existing operator, either an operator who has been granted permit within the state or an interstate operator, violates the permit condition or violates any condition in any notification, rule or regulation, it will be well open to the concerned authority to issue notice to the concerned permit holder, call for their explanation, and thereafter proceed to take action in accordance with law. The learned advocate appearing in one of the applications, namely Can 6 of 2024, submitted that the permit granted to the applicant therein was cancelled, was suspended, and Can 16 was suspended, and the applicant therein had filed a writ petition before this court, but the writ petition was not entertained. This being a public interest litigation, we cannot be monitoring each and every permit, each and every bus which is plying within the state of West Bengal. Therefore, we grant liberty to the individual permit holders to invoke the remedies available to them under the provisions of the Motor Vehicles Act and the rules framed thereunder, or common law remedy in the event the authorities take any action against them for alleged violation of a permit condition or a notification or a rule or a regulation. With this observation, all the applications stands disposed of.
Except and liberty be given to the state transport authority. Liberty be given to the state transport authority to take appropriate step in accordance with law in case of any violation.
Needless to state that if the state transport authority proposes to take any action against the existing permit holders, it has to be taken in accordance with law, in full compliance of the principles of natural justice. So, except Can 4, everything we all the applications excepting Can 4 of 2024 stands disposed of.
My lord, can I make this prayer before your lordship that before my lord the authorities take any steps against any of the parties, give us 2 weeks time so that if we want to approach your lordship, we can do that in the meantime.
No, under the Act, there is a procedure. You can go before the STAT also. There is a separate route. That is why we said in terms of the provisions of the statute.
Very well, before the
common law remedy also. Sir, Can 4, you have to file a fresh report.
Very good. Though, my lord, already in this report, it has been dealt with, but still, my lord, since the Can 4 is now segregated from others.
This is the only application which is now pending. This respondent authority, Can 4 of 2024. The respondent authority
is that I have already filed
the respondent has filed a report, revised third report, which is not to our satisfaction. Since the specific instances of alleged violation pointed out in Can 4 of 2024 have not been dealt with. The learned State Council seeks leave to file a fourth revised report in Can 4 of 2024. The authority is directed to carefully examine the details furnished in the annexures to Can 4 of 2024 and file a report, preferably in a tabulated format. File a report in the form of an affidavit, preferably in a tabulated format. Yes, sir. That we have said, sir. That we have said.
There is one prayer. I want to make only one prayer. Well, this report has been filed. We had no opportunity of filing exception. Well, if we want to take
no, let that report come on record.
Yes.
And if I think your names are not here.
No. I do not know what is there in the report.
Probably you can give a copy of the
copy.
Copy has been served. I have not.
But your clients are not participating.
May I tell one thing? May I tell? Let this report be kept on record and recorded that the copy has been served, and if they want to, they can file. So they are, my lord, the exception. But
exception, the matter is disposed of. How we cannot
to file a additional or
don't complicate things.
Yes.
Please allow them, let them operate. If at all there is some illegality, let him issue notice and accept.
Fine. Now, my lord,
It is submitted by the learned council appearing for the state that in respect of some of the violations which were ascertained, action has been taken by issuing show cause notice. But however, the concerned permit holder has not submitted their reply to the show cause notice, and the authorities have stayed their hands since all the CAN applications are pending before this court. Since by this order, all applications stands disposed of except CAN 4 of 2024, the authorities are at liberty to proceed in accordance with law by following the principles of natural justice.
Only one thing, as Mr. Sen has submitted, something has been dealt with in his report in respect of CAN 4. Your Lordship, can you record it? Not a single. Not a single.
That is why we are called fourth report. Let us see. Next.
Now, the matter will appear.
Let there be an oath versus oath. Come and file an affidavit.
After 3 weeks, we give it.
Well, let is retain his position. And again, I have to mention.
Let it come on such a date immediately after fresh cases.
Why not?
Next.
Item 2.
But I appear for the
No.
This is that nurses matter, where your lordships have passed
yes.
two orders. The order that was passed by your lordship on 7th March 2024. Your lordships kindly
Now, on the last occasion, they said some recent order was passed.
Yes.
Where is that recent order?
That recent order was handed over in court. But my lord, if your lordship looks at my petition, page 74, your lordships will find the order. Page,
next are 4.
Page 74, the 40, whatever. Which is the page? There are 2 pages here. Page 74, Annexure P4. Kindly, my lord, see the ordering portion that is at the next page.
Recent order.
Recent order. Kindly see the ordering portion because, my lord, the first page only records the various grievance, etc. There has been no rejection. The matter has been sent to the finance department. And my lord, this was done on 30th of March 2023. After that, my lord, there has been no movement. Your lordship has taken note of this order in your lordship's order of 7th of March 2024.
Now, what to be done now?
Lord,
No, my lord, just to assist also, my lord, my learned senior, my lord. My lord, the finance has in the meantime rejected on 14th of September 23. That is what date we are getting, my lord, from our written instructions. But my lord, what is to be seen here, my lord, after the recent order which is there in the writ petition, they had made another representation. Now, my lord, this writ petition, which is before your lordship, it appears to be for consideration of that representation at page 77. I was going through the press, but all they want is a consideration of the representation, which is the page 77, which is after the recent order has been passed.
But the recent order doesn't reject.
Conclusively decide because it says that we are sending it to the finance. Now the finance are rejected on 14th of September 2023. Malad, it's in a file noting, Malad, but Malad, what it appears is that Malad, they had also approached before the pay commission. Not only the 6th pay commission. From their earlier representations, it appears that from the 2nd pay commission onwards, they were before the pay commission. Their grievances have always been considered by the commission. It is not that in a slipshod manner, that this parity is being rejected as far as the petitioners are concerned. And also one of the striking features, my lord, in the representation your lordship will find, that is, my lord, if I may draw your lordship attention to one paragraph of the representation starting at 77, kindly take page 78. Paragraph number 2. Paragraph number 2, your lordship will find that their entire basis of the claim is on the basis of similar qualification only. If required, I'll place it, but your lordship knows it. Only on the basis of qualification, parity cannot be sought.
No. Nature of duties and responsibility. And
Point of entry also.
pardon?
How they entered, point of entry. How they entered, which cadre they entered, what responsibility they were discharging, for what hours they were discharging, whether there is such parity or not, whether the administrative department is the same or not, everything. Their plinth, I have gone through, I can show from other representation also. Their claim is only on the basis of similar qualification.
But the issue
I'll kindly take
this
for
has
example.
been considered by the finance department.
You know what you see, the thing is, earlier the High Court was issuing writs directing equal pay for equal work.
Right.
Thereafter, the Honorable Supreme Court said it's not none of your business to do that because various issues are there. Apart from that, the most crucial is the source of recruitment.
Correct.
You subjected the person subjected themselves to a particular recruitment process with their eyes wide open, saying that this will be the scale of pay.
Right.
They will fall under this department, etc. So essentially, it is a question of fact where you will have to whether this qualification, that qualification is same, whether they discharge the same duties and responsibilities. So they said it is essentially a matter which has to go for adjudication before a forum. And writ petition is not the appropriate remedy. Now, the best we can do is to consider the page 77 representation and let them pass a speaking order. You raise a dispute.
This is precisely what we want, Lord, in this petition that we have filed. Because, Lord, your lordship remembers there was an agitation.
No, you are not aware of what passed in the mind of the finance department for rejection.
Absolutely not. Because that has never been communicated. And from September 23, this has not been communicated.
Now, you within 2 weeks, you pass an order with the finance noting this, that, etc., whatever judgments you want to rely upon, communicate. So they will know at least where they stand.
Yes.
Thereafter, they take things forward.
I bow down, Mullah. Kindly give me a bit a longer time, Mullah. Kindly.
3 weeks will be fine, sir.
And
But
Lord,
frustration will set in.
Why don't they, Lord?
I can show another page to amplify my point. For example, if you lordship can you take page 55, second last paragraph, third last and second last paragraph 55. Their case is that the central nurses appointed under the central government are getting more. But these kind of parities cannot be drawn. That is of a different pay commission. That the decision is by someone else. The nature of job is something else.
An organization called Nurses Unity and the secretary of the organization have filed this petition as a public interest litigation, praying for direction upon the respondents to redress the grievances which have been addressed by the organization on behalf of its members dated 27/6/2023. The grievance appears to be with regard to the pay and allowances payable to the members of the petitioner organization, stating that they have been discriminated from that of the similarly placed persons who are serving in the other departments of the state government. Pursuant to a directions issued earlier in WPAP 307 of 2021, the Deputy Director of Health Services, the Principal Secretary, Health and Family Welfare Department, Government of West Bengal, passed a recent order, the operative portion of which reads as follows. Page 76. Pursuant to the above order, a fresh representation has been made on 27/6/2023, which appears to be still pending consideration before the Health and Family Welfare Department. As could be seen from the above order, dated 30th of March 2023, the claim made by the petitioners has not been outrightly rejected. Rather, the matter has been referred to the Pay Commission, 6th Pay Commission.
Matter has been referred to finance.
Finance department.
After recording that the pay commission has already rejected it.
Referred to the finance department, and the order states that the queries / clarifications raised by the finance department in this matter have also been cleared by the health and family welfare department. The learned senior standing counsel appearing for the respondent state on instructions to submit that the finance department has rejected the prayer made by the petitioners for granting equal pay as that of the staff nurses who are working in other departments of the state of the state government. It is a further submission of the learned senior standing counsel that the entire claim of the writ petitioner appears to be based on the similar qualification possessed by the members of the first petitioner organization and that of the staff nurses employed in other departments of the state government. It is a submission that qualification alone is not the sole criteria, but there are several other factors which have to be reckoned to examine as to whether there is parity in employment, parity in recruitment, etc. Time and again, the Honorable Supreme Court has held that it is not for the High Court in exercise of its powers under Article 226 of the Constitution of India to consider equation of two posts or consider equation of two qualifications or to compare the service conditions of two categories of employees and to come to a conclusion as to whether same pay and allowances has to be extended to both set of people. As this involves adjudication into facts which should not be done in exercise of writ jurisdiction. The stand taken by the finance department has not yet been made known to the petitioners, as it appears that it is a file noting made by the finance department. In any event, a fresh representation is still pending consideration before the Department of Health and Family Welfare, the Principal Secretary Health and Family Welfare, dated 27/6/2023. Therefore, we dispose of this writ petition by directing the Principal Secretary, Department of Health and Family Welfare to consider the representation dated 27/6/2023. Take note of the observations made by the Finance Department and pass a speaking order on merits in accordance with law and communicate the same to the petitioners within a period of 3 weeks from the date of receipt of the server
Could we
copy.
be informed about the reasons given by the finance department and give us a
That is the
hearing?
file noting, sir.
Yes, so
Whatever
it
the
has to be
file
incorporated in reasoned order.
So that you can't challenge the file noting.
No, we can't, but at least, Lord, we can, Lord, make a representation based on that file noting.
What is generally, what is it written by the finance?
Can't be one line rejection. They have to consider all this that my learned friend argued.
In the final rejection, it may be one line if there are other notings elsewhere in the file, Malad. That my learned friend cannot have a grievance that every noting must
I'm
have
saying
reason.
that inform us.
But the reasons which will be there in the reasoned order, my learned friend can challenge that, Malad.
But
considering the
What they
finance.
say is, if suppose they are made known about the reasons, they may probably have a supplementary representation to cover that point.
Correct. Yes. Absolutely. That is precisely what I'm saying. That communication.
But he wants the supplementary representative because today I've taken the point that their earlier representation is only on the basis of that. Since I've pointed out that lacuna, now they want to file a supplementary representation.
The order says queries, clarifications sought for from the finance department have been clarified. But that clarification is not acceptable to finance. They have said X, Y, Z reasons we can't accept. If suppose they come to know of that X, Y, Z reasons, they may cover it up in their fresh representation.
Then the matter has to be kept pending, Mulad.
Not required. The learned senior advocate appearing for the writ petitioner submitted that if the petitioners are made known about the stand taken by the finance department as to why the claim was not acceptable, or in other words, why the clarifications given by the Department of Health and Family Welfare is not acceptable, they would be it will enable them to file an additional representation to make submissions on the said point. Therefore, we direct the the concerned authority of the finance department to set out in brief the reasons as to why the finance department did not accept the clarifications to the queries raised by the finance department,
Health department.
and if the gist of the same is communicated to the petitioners within a period of 2 weeks from the date of receipt of the served copy of this order, liberty is granted to the petitioner to file an additional representation to cover those issues as well. Thereafter, the Principal Secretary, Health and Family Welfare Department shall consider the representation dated 27/6/2023 as well as the additional representation that may be given and pass a recent order on merits and in accordance with law. The above direction be complied with within a period of 6 weeks from the date on which the additional representation is submitted.
Right.
Yes, sir.
Well, that date has gone down as 30th of March. That is 13th March.
13th March.
30th is the covering letter.
Earlier I said 3 weeks. That para you can remove because we are clear. Any doubt you give us a draft. Next.
Item 3.
My lord, I am appealing on behalf of the petitioner.
I appeal for the respondents, my lord. Your Lordship, on the last occasion, when the initially matter was taken up, Your Lordship recorded the contents of the writ petition and asked us to submit our written instruction. I submitted the written instruction. My understanding, precise question is that, my lord, the water is being filled up. But I have stated, my lord, in my written instruction, there are 3 premises in the area in question: 3/1 and 3/1/1, Shivon Krishna Ghosh Road. All the lands under that premises belong to the state government. The Kolkata Municipal Corporation is implementing agency certain scheme of Banglar Bari for the slum dwellers. That is not in the pond itself. The pond in premises number 3, Shivon Krishna Ghosh Road, that is there. But there are other 2 premises which my lord, 3/1 and 3/1/1. There is a land. But the government is taking the scheme, has taken the scheme to construct on that plot of land, not on the, but the, on the.
It is in a
My lord,
distance of
may I submit before your lordship? My lord, exception to this report.
This is the petition that I am submitting. Because the land, the
My lord, kindly see that, my lord, order.
My lord, I beg to represent the state, my lord. On an earlier occasion, my learned friend for the KMC has filed one report I have not been served with. Today, my learned friend is filing exception. I have not been served with either, lordship.
in the report they have said the Salboni Jeel is at a distance of 225 meters.
My lord, 1.5 kilometers. 1.1.5 kilometers.
That is
Please
there.
take page, wait sir.
My lord.
Yes,
Please take page 3 of KMC's report.
yes, my lord.
See the last paragraph.
The government of West Bengal project, Banglar Badi project, based on Pradhan Mantri Awas Yojana with approval Ministry of Housing of the 3/1 and 3/1/1, JK Ghosh Road, Kolkata. The proposed project will be implemented an area measuring 7 bighas. The project is now in the final stage in the implementation. The proposed project will not affect the existing Salboni Jeel at a distance of 25 meters. My lord, may I submit before the lordship?
We will ensure that they do not, the proposed project should not affect this water body.
Salboni Jeel. That is, of course.
My lord, kindly, once, kindly, their classification list, my lord, according to their, my lord, my exception, my lord, page 12, it is a Salboni pond. My lord, this is a, according to the master plan of the.
Now in this PIL, this is the maximum that can be done.
My lord,
We will ensure that the Salboni Jeel
Salboni Jeel.
is preserved.
Yes,
intact. And probably we can ask them to put a boundary wall
yes.
around the Jeel.
my lord, one side is the railway track.
One side railway track, the
Railway
other
track,
side let them,
and
sure. And this is a project for the downtrodden people.
Yes, my lord, I am not.
And so many private promoters are filling up water bodies, constructing 20 stories.
Let it preserve that. It is preserve that because by Lord, they are already
They will
notified.
preserve it. They will preserve it. Yeah.
My Lord, they have
petition
noticed
had been
that.
filed.
My Lord, kindly see that they are noticed.
Yes, yes.
Demarcation is
17A, my Lord, they are invoked already.
But the respondents are proceeding to fill up a water body. Report, the respondent KMC was directed to file a report, and the executive engineer within bracket C, BS KMC has given written instructions to the learned standing council for the KMC dated 3rd July 2024. In the said report, it has been stated as follows. Sir, what is clear? The learned advocate appearing for the petitioner to submit that as per the master plan, the water body has to be preserved. After taking into consideration the submission made on either side and the stand taken by KMC in the above mentioned report, we direct that we note that the project, namely Banglar Bari, has been implemented and it is in the final stage of completion. And the KMC has undertaken that the project will not affect the existing Shalboni Jheel, which is at a distance of 225 meters towards north. In order to ensure that the project does not in any manner affect the existing Shalboni Jheel, KMC shall ensure that the area is clearly cordoned off, and if it is feasible to erect a boundary wall to prevent any encroachment or into the Shalboni Jheel, the same also shall be examined by KMC and necessary action be taken in accordance with law. Furthermore, the specific stand taken by KMC that KMC and its authorities have not taken steps, nor there is any contemplation to fill up the existing Shalboni Jheel or any part thereof in any form of manner at premises number 3, JK Ghosh Road is placed on record. With the above observation, writ petition disposed. Next.
My Lord, anything in for construction of the Salboni Hill, my Lord, may again come before your Lordship. My Lord, this is the
you
rule of the day.
You advise your client, sir. Next.
Item 4.
My application. Look, this pertains to certain irregularities that we've alleged in respect of the administration in All India AIMS Kalyani. Your Lordship would have seen, we've deliberately not prayed for an interim order because there's a hospital which is running. So there are allegations that are made. My only prayer today is if this could be dealt with by an affidavit, then if I can bring home the allegations, I will be able to. Otherwise, it will fail. It's as simple as that. There is no immediate requirement to go in and interfere with the administration of it. But there are certain allegations which are there, primarily in respect of the respondent number 3, who is the additional director of AIMS, where he's gone about selecting 2 of such. I'll just indicate, the procurement of medical supplies are happening. And the pharmacy has also been opened contrary to their own procurement manual. Jobs are being assigned, procurement is happening without even calling for tender. Blacklisted companies who've been blacklisted in Madhya Pradesh, Maharashtra by courts, Bombay High Court, Madhya Pradesh High Court, they have been selected for supply of manpower. Straight away, ex facie, these companies now sublet the work, assign it to somebody else. That person is now not even being able to dole out the salary. So when I mentioned it, also indicate now is getting reported in all these newspapers that there's a strike that is going on. So in how we see it, there is some element of corruption and complete maladministration in AIMS. So if they just deal with it and come back, because also the manual for procurement.
No, where is your representation listing out the irregularities, alleged irregularities?
Yes, that time and again this has happened. One such instance
That is basic elementary principle now, sir. You put the what do you say, the alleged accused on notice, saying that it is it's an all India institute, and people who, and it is under the aegis of the Ministry of Health and Family Welfare, Government of India. You should have brought it to the notice of the secretary.
Yes, that is there. Where I brought it to the secretary. Kindly have a look at page 44.
That is to the Honorable Minister, sir. We
Kindly
can't
have a look
ask
at
the
page
Honorable
44.
Minister.
Other representations are not at page.
No, Manoj, this is the ministry. Ministry controls AIMS is a statutory body, so we made the statutory body a party.
We can't ask the Honorable Minister to consider the
No,
representation.
Manoj, the ministry would, not the minister. The ministry
page
would.
60 is minister by name.
Yeah,
We will grant you liberty to give a representation to the
the allegations are in respect of AIMS. If I make representation,
Pan India, is it? Let us close down. You close down the AIMS, sir. AIMS in Kalyan.
not that.
Close
Which is why we did not
All
even
right,
pray
doesn't
for an
matter.
interim order.
And who is the writ petitioner? A busybody? How does he know of all these?
I'll indicate. This petitioner, he firstly is a local inhabitant. He lives in Kalyani.
Yes. But and how did he come in possession of all these documents,
these documents
Somebody else is firing off his shoulders.
No,
We
no
will
one
not
is firing.
encourage, sir. We will not encourage this sort of litigation.
There is absolutely.
How does he get a copy of this e-tender if he's a villager in Kolyan?
He's not a villager. I'll indicate how he gets it. Today, if I can
you have
show.
filed an application under RTA, even then, copy of notifications of e-tender will not be given.
These are this is now available in the market, but if I can show to your lordship.
Is there a pleading to that effect?
No, if I let us say I have procured it from somewhere, which is not going to be countenance. May I just indicate
Court can question the source of the document.
Yes, court can. But one thing I'll just indicate, this respondent number 3 had at one point of time hired his own brother-in-law's company. I write to them. Then they scrapped that tender, take away his tender, and award it to this company, which is now blacklisted. I have copies of orders.
There's somebody else, sir. There's somebody else.
No, there is nobody else involved.
All right. Please show that he is a social worker.
Yes, that your lordship will be able to see. Kindly have a look at page 22.
International Academy of Environmental Sanitation.
And during COVID, I've done all this. If your lordship wants, I'll be, and I have disclosed documents where for the locality also, I have taken people to the emergency ward of AIMS. So because I am there, there's a lot of other public work I do. I am probably be able to satisfy the court that AIMS is practicing contrary to their own manual here.
Sir, you are using some OPD documents of
to show that I have been there.
No.
And also,
the name of the patient is Nipun Das.
Correct. So I have taken them. One more aspect.
No, this is clear invasion of privacy, Mr. Tell Mr. Anjan Roy how he can use a OPD ticket of somebody with the prescription. It is something personal to the person.
Prescription I am using.
You want to withdraw, you withdraw, or we dismiss it with exemplary cause.
No, only one thing.
We have heard the learned.
Lordship will just give me 1 minute. Kindly give me 1 minute.
That the writ petition is not a genuine public interest litigation.
But I'll be able to satisfy your lordship regarding genuineness.
Because the annexures to the writ petition contains documents relating to certain patients, which are all personal details.
Those your lordship will disregard.
Which ought not to have been enclosed as supportive documents to the writ petition. Apart from that, there are documents which are annexed, which are copies of tender submitted, which the source of which has not been mentioned in the writ petition. Above all, before approaching this court for issuance of writ of mandamus, the petitioner who calls himself as a social worker associated with a non-governmental organization has not approached the appropriate authority by way of a comprehensive representation. The above are sufficient grounds to dismiss the writ petition.
Lord, may I just indicate one thing? Your lordship will hear. I know your lordship will pass.
They will close down. They'll shut shop and leave. They'll shut shop and leave.
No, my lord, I for once don't want
I
that.
have dealt with PIL where AIMS they wanted AIMS and it has
No,
come up now.
not even I want, which is why I have not even prayed for any order restraining the hospital to
Don't
function.
use other patient details.
No, my lord, I understand that. My lord,
Let him
may
go. Let him go to
my lord,
AIMS.
may I just indicate two things? I know your lordship has passed an order, but give me 2 minutes. My lord, if I can show to a court, my lord, courts have always disregarded a source of document. If I can show the document shows there is manifest illegality.
It's a wrong understanding of law by me.
No, not that. My lord, bears with me for 2 minutes. Bears with me for 2 minutes.
He heard you, sir. Thank you.
Well, then may I pray for only one thing? Lordship will give me that liberty to at least make this representation to AIMS.
That is one of the reasons for dismissal.
Give me that liberty. My lord. If I today make the representation, I'll not be able to come back.
Once we doubt the bona fides.
But I'll be able to show to your lordship my bona fides here. If your lordship gives me 2 minutes, I'll be able to show that.
Sir. We have dealt with, sir.
Well, your lordship will hear me on this, my lord.
Until the incident boiled down to such a
this is not
so many tenders.
Well, this is not a politically motivated or some other action that has come up before the court. If your lordship gives me 2 minutes, I'll be able to satisfy your lordship on it.
Next, sir, please. Sorry, sir.
Item 5 and 6.
What is this 5 and 6?
This is with regard to that contaminated saline.
Well, on the last occasion, my lord,
Action we read in the newspapers.
there was a direction to file a report where we have the by the chief secretary, where we have the report, my lord, in 2 envelopes. Where I'll tell you why. The main report is in 1 envelope, and my lord, the annexures are in another envelope, my lord, which we want the court only to peruse. The annexures.
The report he can peruse.
Report, if your lordship's direct, I can share without the annexures.
They have taken some drastic action again.
Yes. Actions have been taken.
Compensation. What about compensation?
Compensation has been given.
And my lord, we have offered a job also to the family.
I would like to.
No, I think you have we read in the Times of India. I think they have withdrawn all the.
Yes. These are all in the report also. These are all in the report. 30,000 odd bottles were already used. 3,000 and odd was.
Sir, can you not establish a facility by the state government for supply of this dextrose, all saline?
Can be. Why not?
Because I have seen some government hospitals in my parent state. They have got a pharmacology unit. In that pharmacology unit, whatever tinctures, this, that, etc., they have got a license, drug license, etc. They prepare. In fact, in the Madurai Medical College, Rajaji Government Medical College Hospital was the first to manufacture hand sanitizer. That was not done even in the hospitals like SSKM in Chennai. It was not done. In fact, when I accompanied my Chief Justice when COVID started. Both of us went because 2 of the honorable judges and several staff got affected. That's where they had it in a small dispenser. They gave it to us. So if this process is adopted, and it may not be a very expensive venture. You cater only to supply to government hospitals. You monitor the quality. You will be 100% accountable for whatever has been given, instead of procuring it from the open market. And Mr. Mitro's client will go out of business in West Bengal.
We have stopped them, my lord, from December.
After the.
But Mr. Mitro won't go out of business.
No. Why should Mr.
May I be permitted to file my
online? He's online.
My supplementary affidavit. Leave was granted last time to file the supplementary affidavit.
No, what can be done?
Well, let the report be circulated.
All right. You please give copies.
Yes.
All of
I've got it. No, I've not got yours. I've got
Mr. Seduji has not received the copy.
We've received.
As far as some time to be given to us.
The supplementary. We have heard the learned counsels of the parties. The learned advocate general submitted that the report is ready and will be placed before the court in 2 sets of envelopes. And if the court directs, the report can be circulated, will be circulated to the learned advocates appearing for the petitioners as well as the other respondents. It is further requested by the learned advocate general that the annexures to the report is for the perusal of the court for the present, and therefore the same is submitted in sealed envelope. The sealed envelopes are taken on record and not opened. Copy of the report alone be served on the learned advocates appearing for the petitioners as well as other learned advocates appearing for the respondents. Para. In terms of the liberty granted, supplementary affidavit has been filed by the petitioner, which is taken on record. You want any exception to the required code?
Keep that option open.
Yes, keep that option open.
All right. Liberty for the respondents to file their affidavit in opposition if they so desire. Affidavit in opposition filed on behalf of the 11th respondent is taken on record, copies of which have been served on the learned advocates for the parties. The parties are at liberty to file their reply to the affidavit in opposition if they so desire. But what will be the capital expenditure which you will incur to establish such a industry?
Where we need to discuss with the appropriate persons.
But there are no drug manufacturing companies by the state?
Not to my knowledge, subject to correction. No, I don't think there is any such.
Let the state govern. Let the state not do business. Let them govern. Let us follow the smaller state philosophy, Lordship. State in business may not be always the best.
No, because such a thing has happened, sir. Is it not a wake-up call?
Well, I know, but this can happen with anybody. State-run organization can also, there can be, if at all the report points out any flaw in our
This is repeatedly happening. This is not the first time.
Anyway, Lordship, let the report be seen then, Lordship. Let the report be seen. I have the best credentials. It never happened earlier. Karnataka has been tested, it's been clear.
All right. Whether the 11th respondent has conducted an in-house inquiry as to how this happened?
Yes. We have.
And everything is clean?
Because there are 3 levels.
Then how did it get contaminated?
It's not contaminated. Our contention is that
it's not contaminated. It's our report also.
It's not contaminated. We have 5.5 crore bottles we've supplied till date. And this is the first time that there's been a complaint, and that too, it's not because of our fault.
So your stand is cause of death is not your solution.
Exactly, Malad. We have no role to play in it. Once we supply to the state, Malad, there are also guidelines which the state has to follow. But Malad, we are today not in a position to point out whose fault it is, but certainly not ours.
Let the report be seen. Let us all see the report and then, Lordship, we kindly draw conclusions after considering the report and also our exceptions if we have
by
to
obtaining,
take any exception.
No, Mr. Mitro, by obtaining an order of stay of the blacklisting, the stigma doesn't go.
No, but after that,
it is something like stay of sentence and suspension of sentence.
No, but after the blacklisting was stayed, our product was tested by the Central Drug Laboratory, and this was found to be clear. Because it was similar situation like West Bengal, there was a blacklisting. But then the products were tested by the Central whatever laboratory, and I've annexed the report. It's been found clear. So, but like these happen all the time with all drug manufacturers.
Sir, in that sealed envelope,
yes,
the orders banning them from business.
Yeah, it's there.
That is also included.
Yes. Well, it's at page 70 of the annexure.
So we will not open it today. you please file your exception to the report. We'll probably take it up after 2 weeks.
Or only one thing is that I don't know what the annexures are.
We also don't.
But if we find from the report that they are heavily relying on the annexure,
then we'll
Marador, kindly give me an opportunity.
For the present, AG says it's for the
liberty to mention, then Marador, if by 2 days we'll be able to come back on, if required on Monday, we might mention the matter up for notice to everybody.
Give a date after 10 days.
Very well, very well.
Immediately after fresh cases.
I'm grateful.
Grateful to one.
Yes.
Item 7.
There is this ghat in Howrah. It's called the Uma Pandit Ghat, but commonly termed as Pandit Ghat. My lord, what recently is happening, my lord, we have seen encroachment towards the access of the ghat, not only in the banks, but the approach of the ghat. My lord, I have annexed pictures. The mass representation submitted at least twice, my lord. At page 18 is the, my lord, the mass representation submitted by at least more than 70 people, my lord. We have highlighted our plight, how this bank is being, my lord, encroached upon illegally by making construction. And not only that, my lord, sewage is being discharged. My lord, what we found, my lord, your lordships must be aware of this. What we found, my lord, this order, my lord, which was issued, my lord, under the Environment Protection Act, the River Ganga Rejuvenation, Protection and Management Authorities Act, Authorities Order 2016. My lord, and clause 6 is very important, my lord.
Now the common passage has been blocked.
My lord, being blocked, my lord, we have annexed the pictures.
Who has put up that construction?
My lord, the local residents who are building houses and everything, my lord.
Well, I'm for
The private respondents.
Respondent number 8, my lord. There is a title suit, my lord. I'd like to furnish it before the honorable court, my lord. There is a suit which is pending. Feroz Khan, my lord, we will see. He had initiated the suit. He is the private respondent number 8. The petitioners, they were parties to this particular suit. He has obtained an injunction. Eventually, my lord, there was a order. 144 order, my lord. Also initiated by my client.
The bank is not a private property.
My lord, as far as the respondent number 8 is concerned, my lord, there are suits pending. They have also filed a 144 against me. They had obtained an order. My order was extended. My lord.
No. Suit and 144 proceedings can be in respect of a private property.
Yes, my lord.
Nobody can claim that the ghat is a private property.
No, my lord.
Their allegation is
yes,
not against your construction in some plot of land. In the access to the ghat.
My lord, as far as that particular property goes, I have, my lord, just to satisfy my lord, there are multiple documents which will show I have obtained, and since long I've been there. I've been running a particular shop there. I have documents from the municipality. I have taken necessary permissions. There are plans to that effect. If my lord pleases, I can furnish those documents also, my lord.
What is your?
It is not on the ghats.
My lord, so far as the police report goes, my lord, I find, my lord, may I respectfully hand over the copy of the report by the police. My lord, I shall only travel your lordship with the second page, first paragraph, and it says, my lord, sum and substance that yes, this gentleman, he has been using a godown. And secondly, both of them are trying to communalize the issue. Hence, my lord, 144 has been invoked as well as some 127 of BNS also has been put in place to keep the situation under control.
But
and my third is since it's a port area access to the Ganga, so my lord, there is an act, my lord, that is, my lord, Public Premises Central Act, Public Premises Eviction of Unauthorized Occupants Act 1971. So they can very well, my lord, invoke and proceed.
No, that is one aspect of it.
Lordship.
The larger aspect is that dehorse the internal fight going on between two sets of people. if a common person wants to approach the ghat, his access should not be blocked.
Certainly.
My lord, that is not blocked, my lord.
Certainly not.
That is
But
not
the
blocked.
photograph shows just adjoining the ghat, some construction has come up.
My lord, that cannot be granted by any municipality. My lord, this is a river bank, my lord. And this particular order that, my lord, I have placed, my lord, says no person shall construct any structure, whether permanent or temporary, for residential or commercial or industrial or any purposes in the river Ganga, bank of river Ganga, or its tributaries, or active floodplain area of river Ganga, or its
Photograph in
My lord,
page
is that the
15,
subject matter, my lord?
second
My lord.
photograph in page 15
My lord.
shows a construction which appears to be a very old construction. But in page 13, that appears to be a new construction.
My lord.
First photograph, page 13, new construction.
I'm grateful, my lord.
So therefore, what we can do is, we can ask the DM to nominate one officer.
I'm grateful, my lord.
And he will inspect. After notice to the port authorities, port authorities also have to be noted.
It's a party respondent also.
Port authorities plus the BLLRO's office and the private respondents, let them inspect. If there is any, obstruction to the path leading to the ghat, common path or anything, that alone they will clear.
I'm grateful.
My lord, just one picture, my lord. This is the these two pictures will depict. This is the particular shack or the shop that I have been running. This is if
No, that is 144 is there.
my lord, correct. But my lord, look at the
Condition.
my lord, there is a complete road which is open. My lord.
Let the report
No, my
comes, my lord. Let the report
not at
comes.
all.
Everything will be
Sir,
clear.
obviously, this is without any permission. See, first what happens is, somebody, Chhat Puja time, etc., lot of people come. 5 by 5, they'll start selling something. Then regular flow of visitors are there. Then the 5 by 5 will become 10 by 10. Then small dwarf wall.
Very well.
Calcutta
On top of
usually it
that,
happens below. Shop size is 2 feet and encroachment on the road is 20 feet.
But my
In
lord,
Calcutta it happens so.
Everywhere you go, you can't walk.
but my lord, in that case, my lord, my
This is
construction
exactly
should be
what is
removed
happening,
in
sir.
a separate
About
procedure.
KMC's problem. KMC's problem. They are not able to throw out people in front of their office. In front, you please ask, sir. Mr. Ghosh.
We are not. We are not.
In fact, after one order, they took some action. Fellows were out. Once again, it's come. If you come down Ma Flyover, SSKM Hospital, in this entrance, left side, there is a footpath. Small eateries, about 15, 20, till that end. They cleared everything.
Yes, one.
Now, once again, they have. See, one thing is providing affordable food, but unhygienic atmosphere. Where do they wash the plates? Where do
Lordship's way from Chief Justice's residence to High Court? That area?
Everywhere is encroached, complete encroachment.
My lord, with all humility, my lord.
Then Malik Bazar, we should. They are what he says, dismantling car engines in the middle of the road, breaking the engine. Oil is flowing through.
At the blacktop.
Concern is that the
At the blacktop of the
is
road.
not allowed. That's all. That should be limited to egress and egress.
As a result, what happens? The pedestrians have to walk on the road. They will get run over. A two-wheeler will knock down the lady. The entire footpath is encroached.
Not only footpath, 40 feet road has been converted to 4 feet road, 2 sides car parking. Lordship knows the area in the Baliganj area. This is first one line will start. After a few days, second line will start. So 40 feet road becomes 4 feet. You can't say anything. They will just once your car gets stuck, they will say, "Arey, enough space is there. Go na, go na." This is the way they are doing.
School time is a big problem.
My lord, as far as the PIL is concerned, my lord, the egress and the outgress from the
This is only the concern. We are not concerned about your private dispute. By this public interest litigation, the petitioner seeks for a direction upon the authorities to consider their representations dated 26/6/2024 and 12/9/2024, which are the nature of mass petitions, to protect, to take appropriate action for protecting the common passage leading to Uma Pandit Ghat of River Hooghly. Photographs have been annexed to the writ petition as well as copy of the mass petitions. The learned counsel appearing for the state has got written instructions given by the inspector, officer in charge.
Inspector.
Inspector in charge, Mali Panchara Police Station, Howrah City Police. In the said written instructions, it has been highlighted that there is certain private dispute between the private respondents herein, and the matter was taking a communal turn, which necessitated invocation of the power under section 144 CRPC, and the order is invoked. The learned
prosecution under section 127 BNSS.
and prosecution has been initiated under section 127 BNSS. The learned advocate appearing with the private respondent submitted that there is a title suit. Eighth respondent.
Respondent number 8, my lord.
Respondent number 8 submitted that a title suit is pending and the plaintiff is the 9th respondent. Yes, no. You are the plaintiff.
My lord, in the title suit, I am the plaintiff.
8th respondent submits that the 8th respondent has filed a title suit in TS number 1164 of 2024 on the file of the learned 3rd Civil Judge Junior Division at Howrah. And who are the defendants against certain third parties who have been arrayed as defendants, and the civil court
Civil court has already ordered for
has
the commission.
directed the first defendant not to disturb plaintiff's peaceful possession and is running of his business under the name and style versus Khan Plastics from the suit premises in any manner whatsoever till 30/9/2024 by order dated 29/8/2024, and the interim order was subsequently extended on 30/9/2024. 24. In this writ petition, we are not concerned about the private dispute between the 8th respondent and the defendants in the suit, but we are concerned about the maintenance of the ghat and to ensure that people have access to the ghat, unhindered access to the ghat by any third, on account of any third party encroachments. Full stop. Apart from that, if any construction has been put up adjoining the ghat or the river, the same also has to be examined as to whether it is permissible under the relevant statute. In this regard, the learned advocate for the petitioner relies upon a notification issued by the Government of India, namely Ministry of Water Resources, River Development and Ganga Rejuvenation, dated 7th October 2016, and submits that there is a complete ban on construction on the banks of the river. In any event, these are all issues to be considered by the authorities after conducting a full-fledged inspection. Accordingly, we direct the district magistrate, Howrah Sadar, to nominate one senior officer who will conduct an inspection of the entire ghat area. And before conducting inspection, the office of the district magistrate Howrah shall issue notice to the 5th respondent Port Trust, as well as the respondents 6 to 8 and the defendants in the suit, in the title suit TS 1164 of 2024, and conduct an inspection, examine as to whether there is any encroachment in the ghat area or access to the ghat, or there is any illegal or unauthorized construction put up by third parties, and after notice to all concerned, proceed to take action in accordance with the law. The Commissioner of Police, Howrah, is directed to provide necessary police assistance to carry out the above exercise. The above direction be implemented within a period of 8 weeks from the date of receipt of the call.
I'm grateful.
Next.
Item 8. Image please, your lordship, my lord, in the matter I'm referring for the petitioner, my lord. This is a public interest litigation.
NIA is the petition.
No, my lord, not NIA, my lord. Now, my lord, the grievance of the petitioner is that, my lord. My lord, there is a canal, my lord, for the purpose of, my lord, normal flow of the water for the purpose of irrigation, my lord. My lord, a portion, my lord, has been, my lord, filled up, and the, my lord, they are constructing, my lord, 5 rooms, my lord, they have been constructed, and facing the, my lord, front to the, my lord, bridge of the, my lord, the ridge of the, my lord, canal, my lord. So, my lord, we made a representation being the villagers, one of the villagers, and the persons who are making constructions, my lord, they are out of them, my lord, one person, my lord, is a member of the local Panchayat Samiti. Having informed, my lord, just, my lord, exerting influence, my lord, they have started construction, my lord, we made a representation, my lord, at, my lord, page, my lord.
But after your representation,
but nothing has yet been done, my
they
lord.
didn't inspect
No,
nothing.
no, my lord. So, my lord, what I may pray before your lordship, subject to your lordship's consideration, my lord, let an inquiry be made, my lord, additional district magistrate, my lord, LR, my lord, additional district magistrate, LR, my lord. What type, why, how the construction have been made, why filling a portion of the, my lord, canal as a result.
The private respondents have been served.
Yes, yes, my lord.
Oh, any
Yes, sir.
inspection, Mr.
No, Lordship, Lordship may send the, this is the demand for justice I find at page 22.
Yes, maybe. No, these are grievance, my lord, yes.
So he will inspect.
Yes, my lord. And
Which
file a
authority
report.
will inspect?
My lord, that is, my lord, additional district magistrate, LR, my lord.
LR, that is 2, my lord, at
2, my
page
lord.
22.
Yes.
All right. This writ petition has been styled as a public interest litigation alleging that the private respondents are unauthorizedly putting up construction over an irrigation channel. Utikalika. At so and so in the prayer, it is there. Page 12. Okay.
We have the annex the photographs also.
The learned advocate appearing for the petitioner submitted that in spite of the representation given, the authorities have not taken action and has also enclosed photographs to show that the construction has been put up by blocking the irrigation channel. It is submitted that one of the person who has put up the construction is an influential.
Private respondent 11, my lord.
Namely, the respondent number 11 is an influential person, as he is a member of the
Member of
Panchayat
Panchayat,
Samiti.
local Panchayat.
Though the private respondents have been served and affidavit of service has been filed, none appears for the private respondents. Since action can be taken only if after conducting inspection, we deem it appropriate to dispose of this writ petition with the following direction. The second respondent, namely Additional District Magistrate within bracket Land Reforms Howrah, is directed to cause an inspection of the area in question after notice to the petitioners as well as to the private respondents. And upon such inspection, if it is found that any illegal construction has been put up, action be initiated in accordance with law for removal of such illegal construction. Before taking any action, the private respondents, namely 11 to 13, have to be heard. And if any other person is stated to be aggrieved, he shall also be heard in the matter. The sixth respondent, the officer in charge, Panchal Police Station, is directed to provide required police assistance to enable the second respondent and his officers to conduct the inspection in terms of the above direction. The above direction be complied with within a period of 4 weeks from the date of receipt.
Deep. Item 9.
Item 9, my lord, I appear on behalf of the petitioner, my lord.
I'm for the respondent.
But may I tell your lordship, my lord, the facts, my lord, in a nutshell, my lord. Petitioner, before your lordship, my lord, owns 200 shares, my lord, in a company which has gone into liquidation.
I would take a point of locus and maintainability of this petition as a public interest litigation.
Now, my lord, the fact is, my lord, an application under section 9 of the Insolvency and Bankruptcy Code of 2016 was filed. Company had gone into liquidation, and the applicant who filed the section 9 application It was for a poultry sum of rupees 3.68 crores. The total liability of the company, because the company at the time of formation and subsequently had taken loan, my lord, quantum of which is about 6,000 crores. And money has been taken, my lord, from several public financial institutions, including, my lord, State Bank and other nationalized banks. So, my lord, there has been involvement of public money which company has taken for their own use and benefit. Now, my lord, after the company has gone into liquidation, my lord, further proceeding was initiated by, my lord, the IRP who was initially appointed. Now, then, my lord, IRP became, my lord, RP, and COC meeting committee of creditors was, my lord, held, and, my lord, a company, my lord, finally, my lord, agreed to take over the company, which did not materialize. Thereafter, another company came. He also offered entire offer which the two companies, my lord, made for the purpose of taking, my lord, the entire rights and liabilities of the company. It's about 178 crore, which is very important. That also did not materialize. Finally, the respondent number 44, who has been impleaded herein, he has agreed to take over the company. Prior to that, those two companies, who ventured, to take over, they were all close aides and friends of the respondent numbers 5 to 8, who are the director of the respondent number 4, who had gone into liquidation. At this stage, when this was going on, a forensic audit was called for. And from the forensic audit, it is evident that there is an element of fraud, that is the observation of the auditor, and there are shell companies who have been formed for the purpose of taking away and siphoning off the money. For that purpose, we have come. And one more thing before I show your lordship the 2 or 3 documents, I must tell your lordship, since the proceeding was pending before the company law board, we filed an application for investigating into the affairs of the company. There was a provision, we invoked that. But the proceeding is pending and nothing has been happening for about last 1 year or so. And we have annexed all the orders. I will show to your lordship. Now, today, the primary allegation for which this instant public interest litigation has been filed by the petitioner is that there is an involvement of public interest. Money, there has been an allegation of defalcation of fund, and prima facie evidence of the forensic audit report, which is he is an independent person, that there is an element of fraud. For that, we also made a representation to the respondent number 2, but nothing had happened, nothing is going on. That's why, the jurisdiction of this honorable court has been invoked. And, I know, there is an alternative remedy, but I have carrying a judgment of the Honorable Supreme Court, which says the alternative remedy is no bar, provided I can satisfy the court that there is an element of public interest involved and prima facie evidence of fraud is proof. Now, under this facts and circumstances, may I draw your lordship's attention to, a particular document which is very relevant. That's a forensic audit report. Page 278, if my lords kindly come to.
Now, what is the stage of the proceeding before the...
Nothing is happening. Orders I have annexed. Kindly comes to, the orders first. Then I will show your lordship the forensic audit. All orders I have annexed, page 350 onwards. Page 350 onwards. And I'm just now being told, the application which we filed, that was dismissed for default of late, and a restoration application has been filed. But prior to that, conduct is very important. Lordship would seize, the orders which I have annexed from page 350 onwards.
The restoration application is appearing today.
Learned counsel appearing on behalf of the petitioner is present. Learned counsel, lordship has got that, my lord's page 350, Learned counsel appearing on behalf of the petitioner present. Learned counsel appearing on behalf of the respondent number 5 is present. Duty paucity of time, the matter could not be taken up for hearing today. That's the first order. Now, kindly turns over. The next order. Learned counsel for the parties are present, Learned counsel appearing for the petitioner seeks leave to file a supplementary affidavit to bring on record certain documents which are relevant for proper adjudication in the matter before the next hearing. Then, a copy be served. Kindly turns over to the next page. Again, the parties are present.
Lastly, it was listed on 3rd of January.
Lastly, it was listed, page 353, again, due to paucity of time, it could not be taken up.
3rd January.
3rd January.
Now, the petitioner is before the correct forum.
Lordship, just, may I take, 2 minutes of your lordship's time, just one.
Forensic audit may be a prima facie proof of some irregularity.
Yes.
Now, the application by originally the
He holds 200 shares, my lord, the petitioner, my lord. That I have pleaded in paragraph 3, my lord.
So before the NCLT, probably your locus will be there. Huh? If you come to page 249.
249, my lord.
The original CP is by an operational creditor, Benny Gopal Singh.
Lordship, that's why it said, my lord, section 9 application was filed as the mother application, my lord.
And the company is shown as a corporate
Yes.
record, in which an interlocutory application was filed by India Bulls and Almas Global.
Absolutely.
No, versus Almas Global. So in this, what was the prayer the petitioner sought for in this CP?
My
Where
lord,
is this IA?
in that CP, initially, my lord, I did not appear. I tell you,
Should have.
no, my lord. My lord, I tell you, lordship, I came to know about these things later. This was a proceeding going on inter se between the affairs of the company. Now, my lord.
No. If you, page 349, annexure P13 says.
Page 349.
Shambhunath Jajodia versus
Yes.
EMC. So it is a matter concerning the writ petitioner.
Yes.
Which application did he approach the NCLT?
My lord, I filed an application. I told your lordship at the very outset that there is a provision, my lord. I filed an application after this forensic report surfaced.
Where is that application copy?
Application
my instruction, my lord, is it's a verbatim copy of the
application
pleading which is contained in this writ petition, para by para.
My
But I have noted.
Page 31. Let me, my lord, address my learned friend. Obviously, would have a right of audience, my lord.
This is the NCLT copy.
My lord, this application, my lord, it's in large volume. We couldn't annex, but I have a copy, my lord. Spare copy, if lordship permits, then I can hand over to your lordship. My lord, my prayer was I submitted at the correct copy. My lord, the application, my lord, prayer was to investigate into the affairs of the company.
But I have another copy.
After, my lord, the forensic report, my lord, surfaced. Absolutely, my lord.
Same issue. Delhi promoters are deliberately siphoned out. Duggar family in collusion and conspiracy.
Page 31, my lord, is the prayer made, my lord. My lord, I do not join issue with regard to this, my lord, point that the prayer which I made before the learned company law tribunal is, my lord, quite similar to the prayer that I have made, save except the fact here, my lord, I made a representation to an authority which was not entertained, kept pending, and the proceeding which I filed before the company law board is pending for some time. And the prima facie evidence, my lord, is the forensic audit report, where there is an element of fraud has been observed. Reference has been made to several shell companies. It has been stated in the forensic audit report about the manufactured documents and fabricated documents, my lord. Some properties were mortgaged, which appeared to be, my lord, actually not mortgaged, and the stake and the liability is about 6,000 crore, my lord. Whether, my lord, this is a fit case for an inquiry or not, that, my lord, lordship will consider. And, my lord, I am carrying a judgment, my lord. If otherwise I can satisfy this honorable court that there is an element of public interest, my lord, this is irrespective of the fact that there is an alternative forum, my lord. The court, my lord, can, my lord, take cognizance of this.
Had the petitioner approached this court before going to NCLT,
lordship,
the issue is different. Having gone before the NCLT, and on the same set of facts. Of course, some paragraphs of the pleadings are verbatim copy paste from the NCLT petition. Having exercised the option, it will not lie in the mouth of the writ petitioner to now contend that alternate remedy is not a bar. If he had not exercised that option, come before this court and try to set up a case of fraud of public money. See, if that means every company which goes into liquidation, every company which is a defaulter, every company which is not able to repay its debts, and every company which assets are taken over by an asset reorganizing company, then High Court will have to be monitoring all of them.
My lord, I fully agree with your lordship. My lord, only thing, my lord, kindly
And,
consider the observation of the forensic audit report.
With regard to the respondent number 4, this Kannan Thiruvengadam, he is a chartered accountant or a cost accountant.
Yes.
Mr. Jishnu Chaudhary appeared for him.
Lordship.
And he is appearing for your client.
There.
Yeah.
Mr. Jishnu Chaudhary is appearing.
And there is some interim order we have passed. And his junior kept on mentioning, I said, already there is an interim order. You agitate your matter before it. He has come to some adverse notice. And who's firing off whose shoulder, we don't know. You say that the operational creditor is set up by Mr. Dugar and family.
Absolutely.
They say-
That's my pleading, my lord. That's my case, my lord.
That also, my lord, there is
not
a
only-
provision which he can say before the IBC
No,
court.
no, I have invoked that.
That
I'm
it
not
is
disputing.
it's a-
I have invoked that. There is a provision, my lord, section.
No, I think it's better you.
My lord, may I tell you, lordship, my lord, may I tell you, lordship, my lord, two things, my lord. Since, my lord, I have invoked, lordship, my lord, kindly, my lord, since the proceeding is pending, that is there, lordship, my lord, kindly, my lord, direct the company law board, my lord, to dispose of my. Why not? Why not? Within a certain period of time, my lord.
He had got that application
We
dismissed
have
for
heard you,
default.
sir. Mr. Sen, we have heard you. This is a writ petition filed by one Shambhunath Jajodia, styled as a public interest litigation, praying for issuance of a writ of mandamus to direct the respondent authorities, in particular, respondent number 2 and respondent number 3, who are the Director, Inspector General of Police, West Bengal, and Directorate of Economic Offences, to investigate into the affairs of respondent number 4 versus EMC Limited, having its registered office in Kolkata and represented through the erstwhile resolution professional, Mr. Kannan Thiruvengadam, within bracket RP, and to file a report before this court. Petitioner also prays for issuance of writ of mandamus to direct the respondent authorities to take appropriate steps against the persons involved in the fraudulent, oppressive and illegal transactions as may be discovered and established upon investigation. Interim prayers are sought for freezing of the assets of respondent number 5, who is one Mr. Vinod Digar, son of Sundarlal Dugar. Assets of respondent number 5 to 13, who are private parties, from dealing with, disposing of, encumbering, alienating, and / or transferring their assets and properties in any manner whatsoever. The first hurdle the petitioner has to cross is with regard to the maintainability of the writ petition. It is not in dispute that the petitioner himself has approached the National Company Law Tribunal, Kolkata, in a pending petition in CP number 306/KB/2023. The said petition was filed by one Penny Gopal Singhi as operational creditor, and the fourth respondent company was shown as the fourth respondent company, namely EMC Limited, was shown as the corporate debtor. Record of the proceedings have been annexed as annexures to the writ petition. Interestingly, Annexure P13, Annexure P13 are the bunch of orders passed by the learned National Company Law Tribunal, Kolkata bench, in an application filed by the present writ petitioner in IA within bracket Companies Act bracket close /139 within bracket KB/2024. Copy of the said application has not been annexed to the state petition filed in this writ petition. However, the learned advocate for the petitioner had handed over a copy of the said petition. The prayer sought for in the said application is also more or less identical to the prayer sought for in the writ petition, except that the private respondents who are implicated in this writ petition have not been either named or arrayed specifically, and the petitioner seeks for a direction for conducting an investigation into the affairs of Messrs. EMC Limited in respect of matters indicated in the application for the period prior to commencement of corporate insolvency resolution process by a central agency or an inspector or inspectors to be appointed by the central government, who shall report thereon to the central government. Furthermore, the petitioner has sought for as direction to suitably punish the guilty persons involved in the fraudulent, oppressive and illegal transactions as may be discovered and established upon investigation. Interim prayer was to freeze the assets of respondent number 2 to 10, who are the private respondents in the writ petition, namely the Dugar family. Thus, the petitioner having exercised having approached the National Company Law Tribunal, Kolkata bench, is he entitled to pursue this writ petition styled as a public interest litigation for an identical relief. The learned advocate appearing for the appellant submitted that there are several decisions of the Honorable Supreme Court which has carved out exceptions and stated that alternate remedy is always not a bar for the court, for a litigant to approach the court by way of a public interest litigation, especially when public money is involved, and more particularly in the instant case, there appears to be a forensic audit report which, according to the petitioner, is adverse to the fourth respondent. We would have been impressed with this argument had the petitioner had approached this court at the first instance. Having not done so, we are of the clear mind that the petitioner cannot be permitted to pursue parallel remedies both before the learned National Company Law Tribunal as well as before this court, that too by way of a public interest litigation. If the proposition as advocated by the learned advocate for the petitioner is to be accepted, then the constitutional courts would be flooded with public interest litigations, only considering cases for ordering investigations into the affairs of private limited or public limited companies which are gone into liquidation, or there is any adverse report drawn by certain statutory authorities. This, in our opinion, cannot be the role of a constitutional court exercising jurisdiction to entertain public interest litigation. Therefore, we are of the clear view that the writ petition is not maintainable. Hence, the writ petition is dismissed with cost of ₹1,000 payable to the West Bengal State Legal Services Authority, not later than today.
But kindly consider,
or 10th February 2020.
Only one prayer, kindly direct the learned company law tribunal to dispose of this matter. This much,
appearing for the petitioner submitted that a direction be issued to the National Company Law Tribunal to expedite the matter. As we have held that the prayer sought for by the writ petitioner is not maintainable, and he is not entitled to approach this court, having availed the remedy available before the tribunal, we cannot issue any directions as sought for, and such prayer stands negative. Next.
May I file the affidavit of service?
Affidavit of service taken on record.
Obliged.
The
cost part of lordship considers only very well.
They are big people, sir. This is like we could have imposed ₹1 also.
I understand, what is
your client should understand, because we are aware. See,
since lordship
one thing is,
my lord,
please don't take the bench for granted.
No, not at all.
The bench will not forget matters.
Lordship.
Okay. So the moment I saw Kannan Thiruvengadam's name, immediately it struck a chord somewhere. He is the RP who was appointed.
Lordship.
There is action taken against him. He is before us. There is some interim protection granted.
This matter.
Same, Kannan Thiruvengadam. And we tell you the name of the learned advocate, presently designated as senior advocate.
Honestly, I didn't know this.
The cause title is a bit defective because now the RP has been substituted by the liquidator. There is a liquidator appointed.
Cause title is not defective. It says erstwhile RP.
Very well. Erstwhile RP.
But this was not brought to my notice, Lord. I can candidly confess before your Lordship. But
We are
one,
not blaming you, but then
no, Lordship is hearing, my Lords are hearing this matter. My Lord. Obviously, Lordship knows it, my Lord.
court will remember.
It's in Lordship's mind. But Lord, one thing, my Lord, just for the sake of repetition, since my Lord, Lordship is sitting, my Lord, and hearing, my Lord, this public interest litigation, one observation, one sentence, just let the matter can be disposed. Expediting the hearing will not prejudice anybody, my Lord. Otherwise, my Lord, what happens in company law, but my Lord, there are several applications, my Lord.
Not a 227.
That is not.
Why not?
You
Where is
please
the bar?
address your claim. Next.
Very well.
Item 10.
I'm grateful, my Lord.
But I appear for the respondent number 6.
But then, my Lord, kindly, my Lord, one thing, my Lord, kindly, my Lord, consider, my Lord, I'm tempted to say this by my learned junior, my Lord, that this will not, my Lord, this will not be construed or, my Lord, any kind of admission or any.
We have said not maintainable. Your client took the risk, he'll enjoy.
Very well. Otherwise, my Lord, this order may be shown, my Lord.
Doesn't matter.
Very well, my Lord. Grateful.
Next, unauthorized construction.
This is the second round of
B63.
public interest litigation.
A waste of time, sir. All.
No, this is the
We can
second
issue
round.
one direction. State of West Bengal shall inspect all properties in the state within a period of 6 months and take action in accordance.
Lord, kindly takes your
Can
lordship.
do some matters of.
Lord, kindly takes.
What is your instruction, sir?
My understanding because dealership passed an earlier occasion.
Page 106, my Lord, the earlier order passed by your Lordship.
That passed an order.
And we have complied with the order at page 110.
Not complied with. Lord, that's what my allegations are, Lord.
Now the issues he is raising is they are disputed questions of fact. Whether this
No dispute at all. Everything is on record. Everything was a part of record, Lord, considering that your Lordship had passed an order recognizing, Lord, the existence of a passage. Lord, the passage under the rules has to be at least 2.5 meters.
Sir, after inspection, they have recorded that it transpired no encroachment has been made by respondent number 9, Srimati Mamta Mondal, of B63, or by the writ petitioner or any third party in the affirmative.
That is prima facie, Lord, incorrect. That is prima facie incorrect. Lord, may I take your Lordship, Lord, to the building rules once? Lord, kindly takes to the building rules 83, rule 83. Lord, this was the stand, consistent stand, Lord, taken from in the first public interest litigation. Lord, considering that, Lord, your Lordship had recognized, Lord, that there is an existence of a passage. Now, Lord, what they have done, this by the way of this plot, this passage has been encroached. That was my allegation in the
your photograph shows there is no encroachment.
Lord, that is the encroachment. Kindly see, Lord, the photograph.
No, there is a what is it? That payment curb is there, blue and white.
Yes, Lord, that is the encroachment. Your Lordship sees the width, Lord, on the southern part and width on the northern part. Lord, kindly, Lord, kindly sees this 112.
But whether you have granted permission, building plan approval for this?
I am for the respondent number 9 and 10.
You obtained plan.
Actual is a 40 square meter land. It's a very little land and it belongs to the Setuka, poor Setuka family. To give the listen to the Setuka family, the petitioner filed the appeal one after another. That is the main thing. It is not in the category of the appeal because public interest not being hampered and public interest not involved in this case.
No.
That is the main.
We can sympathize with
Namely, sanction the building plan. According to sanction, I have completed the construction. And I have a sanction plan with me.
Lord, kindly takes the building rule once. If the sanction plan has been issued, the sanction plan has to be cancelled.
All along, they are terming this strip of land, which is a part of our land, my Lord, the project area. And this petitioner resides by the side of that project.
Yes.
He is not the allotee of our project. He has obtained building plan showing that strip of land as uniform 100 meters, 100 foots.
This argument
and based on
in
that,
the last occasion also.
just to get larger FAR, he has done that.
If you are a neighbor,
my lord,
this can't be a PI.
Lord, on the same
He's a
cause of
neighbor.
action, Lord, on the same cause of
Lord,
action, the
Then
previous,
there is a private matter.
Lord, on the
And on the last
May I-
occasion,
Lord, may I?
your lordship's
On the
direction,
last
project
occasion
plan
also,
was
Lord, the same
produced
thing,
before this honorable court.
Lord, surfaced. The same argument surfaced.
Project
Lord,
plan was,
considering that your lordship
yes,
had entertained the PIL and
They-
passed this order.
they are trying to term this strip of
Lord,
land as
kindly
specific.
consider, kindly,
And we have stated in our report.
Lord, the report I shall deal with it. Lord,
And-
kindly
after-
takes the building rule once.
After-
Lord, kindly takes the building rule once. Kindly takes the building rule once.
And we had taken the maintainability at the first instance also.
Yes, at the first, that was turned down. That was turned down.
And considering all these, my lordship was
Page
pleased to,
24 is the
lordship
Mouja
was
map.
pleased to
Page
pass
24,
this
my lord, is
direction.
the Mouja
And
map.
direction we have complied with
Lordship
the
would
direction.
find this passage. Your page 24 is the Mouja map. Your lordship would find this passage. It's consistently uniform. There is no question of Lord. It's
It
just
was
on the
not
left hand side
uniform,
bottom.
and the plan they have
Left-hand side.
submitted in our.
I
affidavit,
understand
have
we must be
disputed.
submitting one at a time. Lord, page 24, your lordship sees, Lord, right hand side, left hand side bottom. Your lordship would find, Lord, this is the passage, and on the right hand side, Lord, top, your lordship would find the legends, the description of these map. Your lordship has seen, Lord, this mark. I'm sorry, my lord, that's a bit, Lord, a larger version. Else, my lord, Lord, here. Your lordship has seen this mark? This mark, my lord? On the left-hand side bottom. Left-hand side bottom. Your lordship has seen this mark, my lord?
Disputed plot B63.
B63. And your lordship has also seen this passage. And your lordship sees this mark. Lord, brick, sort of brick mark. Kindly comes to the legend column on the right-hand side top. Right-hand side top, this part. Your lordship would find on the sixth entry, that's a brick pavement road. It is their map, certified by KMDA.
No, that we have
Certified by
disputed,
KMDA?
and the original plan we have in our affidavit, we have disputed the plan they have submitted.
Lord,
That
this
is why
their plan.
that is why your lordship was pleased
No,
to
no.
ask.
No, this says KMDA.
It shows. Then your lordship directed us to produce the original one. We had produced before
Where
this.
is that original one?
Original one was on earlier occasion was produced.
Considering
one
that
of
your
our
lordship
engineer-
found there is the existence of a road.
One of our
Considering that.
engineer was present.
The road, sir.
Yes.
There is no problem. There is a road. What is the width of the road? Is the
My lord.
dispute.
Absolutely.
So now to KMDA, this is not the correct plan. That's what they say.
Lord, they had said that on the last occasion also, your lordship considered the plan.
We have
And my lord had
produced
found that.
We have produced
Now,
that.
Lord,
We have said in our affidavit that this is manipulated one.
now,
In our affidavit, we have said.
Lord, if this is a manipulated version, I'm ready to face any consequence. If this is a manipulated version.
And the actual plan we had produced.
Where is your affidavit?
কোনো প্ল্যান দিয়েছিলাম আমি Lord kindly comes to page 76. Perhaps Lord he is talking about this plan. এটা তো
কোনটা?
এটা বলছিল তো
প্ল্যানটা ওই প্ল্যানটা তো আর অরিজিনাল প্ল্যানটা তো আর-
original. This is this is a part of supplementary affidavit filed in the first writ petition by KMDA. This is a part of this, page 76. Here also your lordship would find existence of this road.
Where is that 63B? You have not colored any of the plans.
Lord, 63 is here. Is here. Left hand bottom, left hand bottom. Lord, this was exactly what was supplied to me, Lord. I couldn't have got a better copy. Lord, whatever I have, Lord, I have produced with your
But
lordship.
here in this plan, the width of the road appears to be uniform. But photograph shows road.
It is not uniform. somewhere it is 12 feet, somewhere it is.
Sir, this is your plan. It shows that the road is uniform.
No, this is not at all. Our stand is this is not at all road. It's a strip of land that is not uniform, and that has in our affidavit also we have mentioned that somewhere it is 12 feet, somewhere 10 feet and 9 feet.
Sir, you have to support it by a proper plan, which is authenticated plan, which is maintained by you. Photograph shows that the passage gets narrow at one point of time, and
Yes.
obviously this construction is jutting out.
Well,
and who did the inspection? Which authority?
my lord directed
Inspection.
the concerned officials. It was
Page 111 is
Lordship, 111.
Sir, you take 112 and 130. You have given him color photograph?
colored photographs.
No.
Not,
You see this color photograph?
Black and white. All my affidavits.
12 and 130.
I'm grateful, Lord.
It can't be like this, sir. Either it's a uniform passage. At one stage, it can be 5 feet, and another place, it can't be 2 feet. You turn over. There's a old construction, there's a new construction. The old construction is within the width.
This is new thing, my lord. They are producing, my lord. And the affidavits we have filed earlier in earlier proceeding, my lord.
All have been annexed.
We should stage of the construction.
Lord, they have raised, Lord, two-storied construction, merrily making construction. Now they are saying it's complete.
You put into occupation.
Yes, yes. Lord, most important.
It's a very little AP, sir. This photograph shows there is a old construction. And you have constructed about 5 to 7 feet away from the old construction.
No.
10-story building was there.
Lord, most important.
We have constructed the first floor after getting the permission of the king.
And this construction is in violation of the building rules. It's a row housing.
After hearing the learned advocates for the parties, prima facie that the construction put up by the private respondent appears to be an unauthorized construction as it is projecting into the road. However, the inspection conducted by the various authorities pursuant to an orders passed in an earlier petition states that there is no encroachment made by the ninth respondent, Srimati Mamta Mondal, or by the writ petitioner or any third party in the said plots. The first aspect to be clarified by the KMDA is which is the layout plan, which is the correct layout plan, which was approved by the concerned department. The KMDA is directed to produce the correct layout plan of the entire area, as well as all documents concerning the application submitted by the private respondent for approval of the construction which has been put up. List these documents be produced along with the report in the form of an affidavit by the concerned authority of KMDA.
The private respondent is our LOT.
Meantime, Lord,
We are not the sanctioning authority, the KMC to approve the building plan.
Lord, KMC has said there is no building plan.
That's the development.
Yes.
You draw the development plan.
Development, we shall.
That plan you produce.
Yes, yes. Earlier occasion, we have also produced. Again, we shall.
Building plan approval, the authority of KMC is directed to produce the copy of the application submitted by the private respondent and the approved plan, which was issued to the private respondent.
Lord, KMC has said
For such land, KMDA have approved the building plan.
KMDA authority.
That is now it is KMDA.
No, this is perhaps this is the project plan.
No,
The building plan.
Building plan KMDA.
Building plan KMD.
Lord, KMDA is submitting, they have no authority to issue a building plan.
Where is the approval? Sir, in this, the plot has not been shown. That will be there in the detailed plan.
Project plan is required. On the earlier occasion, we had produced.
Submitted by the
Again,
private advocate
we
to the
shall
private
produce that.
respondent, that KMDA, originally known as CMDA, had granted approval of the building plan on 22/9/2003. Records in this regard also shall be placed before us. Next.
Melodies.
Yes, Lordship has got.
No, my lord is keeping this matter returnable.
2 weeks or so.
I'm great.
Lordship.